obliged, my lords. My name is Felix Olindi, the Attorney General of the state of Uganda, appearing on behalf of the applicant with counsel Edwin Calvin Nagenda and Melissa Nyanja Chantal in the matter between Solar Wheels Eco Motors versus Sky Connect, Green Drive, and the Attorney General. The applicants here in this court are represented by counsel Jonathan Areva, Marvin Seriko, and Kimono Stella. My lords, I yield the floor to the applicant. My lords, if it pleases this court, I will now proceed and submit on the merits of the case. My lords, before I wish to re-echo to this honorable court that for more than 1 century, we have had the innovation of automobile law. It is on that premise that we are before this honorable court that we seek that in competition in the relevant market, there should be not just competition, but fair competition. Having established that this case will be premised squarely on competition law, we find it prudent and imperative to inform this court that the Ugandan jurisdiction has not traversed to a great extent competition law in the statutory legal regimes, but also in the decision of the courts. And as such, my lords, it is on that basis that you will hear in our submission us rely heavily on persuasive jurisprudence from the European courts and other jurisdictions. My lord, that being the case, I will now proceed to submit on jurisdiction. My lord, as I've highlighted, this is a peculiar case. And in the premises, it rises from a decision of a parliamentary committee. My lords, work came up with a decision that we seek as the applicants to challenge today. And to that end, there is no specific law that governs the challenge of those decisions that come from work as of now. We understand that the Competition Bill of 2022 is pending assent of the President that would ordinarily describe that stability. My lords, the principle of admissibility connotes that litigants appear before a court when they have exhausted the available local remedies. As I've earlier noted in my submission, that we come from a decision of a parliamentary committee. The High Court is the only proper forum vested with jurisdiction to hear this matter. As such, we submit that both the test of jurisdiction and admissibility are met, and I will now proceed to submit on the merits of the case. My lords, issue 1 is to the effect that Green Drive's exclusive agreement with Sky Connect for access of 8G ultra-high frequency constitutes an abuse of its dominant position. And I invite this honorable court to adjudicate this issue in the negative. And while at that, we will establish 2 major limbs of argument. 1, that Green Drive and Sky Connect both have a dominant position in relevant markets. 2, that they have both violated such a dominant position. Your Lordships, I will invite this honorable court to be persuaded by the jurisprudence of the European Court of Justice in the decision of La Roche versus the Commission, a case of 1979. My Lord, where the European Court of Justice defined a dominant position to be and the position of economic strength by an enterprise individually or collectively, which gives it power to behave to an appreciable extent independently of its competitors, consumers, and customers. And in particular, my lords, that forecloses enterprises from competing from such a relevant market.
So what percentage do we look at to determine a dominant position?
My lords, I will invite this honorable court to be persuaded by the competition bill in part 5 that suggests and the rationale therein is that for more clear threshold, 30% or that should be held by a dominant, by an entity to justify a dominant position. However, your lordships, the jurisprudence of the European Court of Justice further has established indicative factors that we might look at to establish a dominant position.
But what's the dominant position in the jurisdiction you cite? So you're cherry picking, you pick a competition bill. What's the percentage in the European Union that you are citing?
My lords, the European Union and the European Court of Justice has simply put indicative factors that we look at to establish a dominant position.
So you're saying there are no percentages in the EU?
My lord, the percentage that is given varies from different statutes. For example, if I may refer you to the Treaty for the Functioning of European Communities, it suggests a 10% in the relevant market, your lordship. My lord, I submit to this honorable court that pursuant to the decision in United Brands versus the Commission of 1975 before the European Court of Justice, and the decision of USA versus Microsoft before the Supreme Court of the United States, I will juxtapose the two decisions to establish what is a relevant market. And in these two cases, the latter case established that while looking at the relevant market, we must look at it from the standpoint of the product. And your lordships, in that case, while Justice Mackenzie Stewart was interpreting what then was the banana clause, he established that since bananas were demanded more than any other fresh fruit, then they constituted a product, and as such, bananas were a relevant market. Your lordships, in the latter case, which is now, in the former case, my lord, which is now USA versus Microsoft, court held the opinion that computer chips are part of computers, and to that end, they cannot be distinguished from computers, and therefore that form the relevant market.
But now you're taking us to the USA. How does the USA consider a dominant position, and how does it vary from the EU and the Ugandan one, and which one do you want us to follow?
My lords, as I highlighted before, that we shall refer to different jurisdictions, and in the case I've cited here, the Supreme Court is of the opinion that we should look at the product to establish what the relevant market is, and then what is the dominant, or if an entity has a dominancy in that relevant market. And that is the analysis I'm trying to make before this honorable court. My lord, in the premises, I therefore invite this honorable court to consider the fact that, first of all, pursuant to paragraph 3, line 3 of the facts, Green Drive enjoys a significant market share of the manufacturing and trading of electric vehicles. Subsequently, Green Drive also has entered, pursuant to paragraph 4 of the facts, has entered an exclusive agreement with SkyConnect, which is the exclusive supplier of 8G ultra-high frequency to supply LG 8G ultra-high frequency to Green Drive for the access of their smart charging chips. To that end, we submit that in that case, SkyConnect holds a dominant position in the distribution of 8G ultra-high frequency because it enjoys it exclusively. And then when Green Drive also joins an exclusive agreement, they join such dominancy even to the extent of the manufacturing of 8G enabled smart charging chips. To that end, we submit that it is clear that Green Drive and SkyConnect enjoy a position of dominance. My lords, after establishing such, it is now imperative.
What percentage of the relevant market do they have?
My lords, concerning the 8G ultra-high frequency, Green Drive enjoys, SkyConnect enjoys 100% exclusive rights of distribution. And my lords, pursuant to the access of the smart charging chip that then SkyConnect, then Green Drive joins, it also enjoys such a percentage. Considering that also in the trading of electric motor vehicles, then Green Drive also enjoys a significant market share in the trading of electric motor vehicles. However, our case, and to be pointed, my lords, lies on electric motor vehicles that use smart charging chips that can access 8G ultra-high frequencies. And to that end, we submit that both Green Drive and SkyConnect have enjoyed 100% dominancy in such a market. My lords, I will now proceed to submit on how this dominancy has been violated. My lords, I invite this honorable court to look at clause 10, sub-clause 6 of the Competition Bill of 2022, and also in tandem with section 8 of the East African and Competition Act, East African Community and Competition Act. These two seem to suggest, my lords, when read together, that when you foreclose competitors from accessing and when you substantially foreclose competitors from accessing an essential facility in innovation, then you have abused your dominant position. And your Lordships, this position has been reiterated by the European Court of Justice, again I cite it persuasively, in the case of Oscar Brunner versus the Commission, judgment of 26th November 1998. My Lords, we submit that to that end, when Green Drive and Sky Connect entered an exclusive agreement barring any other competitor from accessing 8G frequency, irrelevant of what they have innovated, then they have foreclosed them from entering this relevant market and competing. And that has an adverse effect on competition in the relevant market and violates antitrust laws. My Lord, our second submission is that...
What is the adverse effect here?
My Lord, the adverse effect is that once the joint venture, which includes Solar Hills and Eco Motors, do not access 8G ultra-high frequencies, then they cannot innovate smart charging chips that operate as such. And to that we submit that when you stop them from entering such ambits of innovation, you're stifling competition and innovation, and such is an adverse effect in the relevant market. My Lords,
we've also seen later on in the facts that it's stated that they actually come up with a way of circumventing this and accessing the 8G nonetheless.
Yes, my Lord, and when they came up with that way, they were taken to an investigation, and that's why we are before this Honorable Court to litigate and show you that that way in and itself and from the submissions of my co-counsel was justified.
All right. And then I heard you cite the ESC Competition Act, and what I really wanted to understand, because I would think that pertains to, cross-border transactions. Would that be relevant in such an instance?
My Lord, I highlighted at the start of my submission that we will quote a lot of persuasive precedents. What we borrow from the East African Communities and Competition Act is simply the principle, so that we can enable this court to analyze whether these actions were in interest of fair competition or anti-competitive. And to that end, we are seeking that it is merely persuasive. My Lords, I have the eyes on the clock, and it seems my time is fast spent, so I will rush to conclude. My Lords, our second limb of argument is that Sky Connect and Green Drive leveraged their power, their dominancy, from one market to an adjacent accessory market, as I highlighted before, from the jurisprudence in United Branch versus the Commission by the European Court of Justice, specifically the decision of Justice Mackenzie Stewart. He highlighted that when an entity enjoying dominancy in one relevant market leverages that power from that relevant market to another, notice here, my Lords, that I'm stating that Green Drive and Sky Connect leveraged from Sky Connect enjoying exclusive rights to sell 8G frequency and Green Drive enjoying dominancy in electric vehicles trade to manufacturing and exclusively produce and supply 8G smart charging chips. Then they leverage their power from their various dominant positions to the positions of electric motor vehicles that use smart charging chips. My Lord, we submit that that is violation of their dominant position, subsequent to the jurisprudence again of the European Court of Justice in the case of Terak Park versus the Commission of the People of the European Communities. My Lord, as I conclude, we submit that from the facts, the exclusive agreement is one that does not disclose its duration. And to that end, we invite this Honorable Court to be persuaded by the report by the Commission for the European Communities, and I notice that my time is fast spent. If you could allow me just 1 minute to conclude. Much obliged, my Lords. My Lords, the report of the communication of the Commission of the European Communities of 2009 suggests that perpetual exclusive agreements are in themselves anti-competitive and abusive. We therefore invite this Honorable Court on these three grounds: foreclosing competition, leveraging power from one market to an adjacent market, and lastly, perpetual exclusive agreements that will meet the threshold that the exclusive agreement was an abuse of a dominant position and it should be rescinded. And this court should hold that this agreement was unlawful and it should not stand. I will now yield the floor and invite my co-counsel to address you on issues 2 and 3. Much obliged, my Lords.
my lords. For court record once again, my name is Marvin Insereko, counsel for the applicants. My lords, I will be submitting on the merits of issues 2 and 3, respectively. My lords, issue 2 reads that whether the Eco-Motors and Solar Wheels collaborative partnership, also known as the JV, has transformed into an anti-competitive cartel. My lords, according to paragraph 7 of our statement of facts, Eco-Motors and Solar Wheels are two different companies that are prominent manufacturers of electric vehicles. My lords, they come into a joint venture where they join hands to venture into a new form of innovation, which is innovating and coming up with smart charging electric, remote charging electric cables, and also to come up with a new cost-effective ride-hailing business in this market. My lords, with that, we pray that this honorable court allows me the latitude to define what a joint venture means. My lords, I will rely on the East African Communities Competition Act, which defines a joint venture to mean an enterprise subject to joint control by two or more undertakings which are economically independent of each other. My lords, important to note is that these undertakings must be specifically independent from each other.
From my perspective, you cite some EU cases, some US cases, something in the competition bill. Now you use something in the East African Community Act to define a joint venture. I don't see consistency. So what should we be using, or we should follow whatever law you cite to define? Or do you, what are your thoughts on that?
Much obliged, my lord, and thank you for that indulgence. My lord, as earlier on established by my land colleague, the jurisprudence in Ugandan legislation is still shallow on issues or matters to do with competition law. My lords, therefore, we use all resources in our power to look for persuasive decisions to help this honorable court and guide this honorable court to come up with maybe a decision that we shall start relying on in the Ugandan jurisprudence. And with that, we pray that you allow us to use the persuasive jurisprudence and statutes. My lords, a cartel, on the other hand, allow me rely on the decision, a 2009 decision of the Supreme Court of the United States, in the case of the United States versus the National Lead Corporation, a decision of 2009. My lords, this court defined a cartel in a scope of business and competition law to mean, in its versatile form, to mean an agreement of companies or sections of companies having common interests so as to prevent extreme or unfair interests. My lord, I also pray that this honorable court allows me to persuade you with the treaty on the functioning of the European communities, citing Article 101 of this treaty, which prohibits, regulates, and establishes agreements, decisions, and concerted practices which have a negative adverse effect on the market. My lords, it is also imperative to note that cartels in themselves are not prohibited or banned, according to the decision of the European Court of Justice in Cowridge versus Graham, a 2009 decision. However, my lords, the court went ahead to declare as illegal all agreements, decisions, and concerted practices that are against antitrust laws. My lord, with that, the applicants submit that there is no evidence in our facts that the joint venture between Eco-Motors and Solar Wheels constituted to any breach or violation of the antitrust laws. With that, my lords, we submit.
Counsel, what I would love for you to speak to is, because I know that also in the facts, there is certain behavior, especially in paragraph 13, that is cited, the sharing of sensitive business details as well as pricing strategies. Don't you think this would fall within the ambit of the unfair, anti-competitive behavior that we are talking about?
Much obliged, my Lord, and that is a very interesting question, my Lord. However, my Lord, allow me answer your question with a persuasive decision of the Supreme Court of Zambia in Tokyo Vehicles Limited versus the Competition and Consumer Protection Commission, a 2015 decision. My Lords, in this case, the Supreme Court of Zambia clearly held that arguments and concerted practices like that of sharing information in a collaborative sector do not in themselves constitute to cartel projects. And with that, my Lords, we submit that the information that was exchanged was information that was limited to the objectives of the collaborative research, which was in the joint venture.
But how do we determine the test? Because when people playing in the market share information, we should be worried as consumers in the market. If MTN and Airtel are comparing notes, that means they could decide to manipulate the market. Can you perhaps address this court on what the Court of Justice of the European Union has said is crossing the line when you share information?
Much obliged. My Lord, thank you for that guiding question. My Lord, courts have over time and in different jurisprudences held that where you share information beyond the scope of your collaborative partnership, then there you have committed antitrust and anti-competitive behavior.
But you can define collaborative partnership as anything. What have the courts said? Because I know that there are some decisions where if it's a perishable good, it's important to compare prices, and the Court of Justice of the European Union has said that's permissible, but they've also said there are instances where it isn't. Can you address us on when we draw the line besides what can be interpreted by anyone as collaborative? What have the courts said?
Much obliged, my Lord. My Lord, I would pray that you are persuaded by the threshold that has been set by the European Court of Justice, the effect balancing test. My Lord, the effect balancing test looks at the effect of a concerted practice vis-a-vis how it is going to affect the competition or the market. My Lord, in this manner, I also submit that the exchange of information that was done by Ecomotos and Solar Wheels was specifically for the objective of coming up with new innovations as witnessed under paragraph 7 of our agreed facts. My Lord, with that, the applicant submit that the joint venture between Ecomotos and Solar Wheels was also not colluded in nature. My Lord, collusion simply means that these two parties or companies have come up and they have become one to come up with elements like price fixing, limiting the market, limiting the supply, production, and investment. My Lords, there is no evidence in our facts that Ecomotos and Solar Wheels limited the market, limited the supply, or production. And with that, we pray that under issue 2, this Honorable Court finds that.
How would you qualify paragraph 3, which is a price strategy, as not limiting market? And my colleague gave you an example of a telecommunication company as MTN over 7 million subscribers, Airtel with maybe, 5, and they come into an understanding to strategize on price. They're tagging a kind of phenomenon on how to deal with the price. Don't you think that limits?
So, my Lord, I pray you be persuaded by the European Union guidelines on horizontal cooperation agreements that was adopted on 16th July 2023. My Lord, what we have here is a horizontal agreement between Ecomotos and Solar Wheels. My Lord, this agreement the threshold therein is that the information exchanged by these two companies should not proceed or should not be beyond the objective of their collaboration. And as earlier on established, the information was shared and did not proceed the scope of their collaboration. My Lords, if you permit me the latitude
about the scope of the collaboration, I know that in paragraph 7, what is included. There is access to 6G and 7G frequencies. Is it of any consequence that now we see the JV, delving into 8G frequency? Is that of any consequence?
Much obliged, my lord. My lord, it is important for us to note that, especially in technological innovations, a newer technology shall always take the first priority. My lord, we have 6G and 7G smart charging chips. However, there is a new technology of 8G chips. Of course, the market is going to opt for the newer technology. Now, after applying for a license, and Sky Connect, which has the exclusive rights to license any other company to use 8G ultra high frequency network, and it denied the joint venture. That's right. My lords, the joint venture came up with another innovation of smart charging systems that could intermittently access 8G ultra high frequencies. With that, we submit that this was a legitimate innovation, and as such, this honorable court finds that the joint venture did not constitute to an anti-competitive cartel. My lords, if it may please this court, I pray to proceed on with the submissions of issue 3, which is also the last issue of the applicants. My lords, issue 3 reads that whether the collaborative research and development efforts between Ecomotors and Solar Wheels constitute legitimate technological innovations. My lords, according to the decision of the European Court of Justice, the decision of Volkswagen versus the Commission of European Communities, it defined a collaborative research and development as a partnership between two or more parties who work together to achieve a common goal. My lords, the common goal that was aimed at being achieved by the Ecomotors and Solar Wheels was to simply come up with new technologies for remote charging, and also to come up with a new business of cost-effective ride-hailing services. My lords, to be put in a context, the new business of cost-effective riding services is equivalent to what we have right now as the Uber, smart cars, or Lyft. Those ones. Now that is what they intended to innovate, which was not in existence in Wakanda at that time. We therefore submit that the research and development efforts constituted a legitimate technological innovation, and with that, we pray that this honorable court is convinced or is persuaded by the decision in T-Mobile Netherlands versus RANS, where the appeals court of Paris held and said that where there is an innovation that intends or that is aimed at solving a social pressing need, such an innovation should be applauded, and as such we pray that this honorable court be inclined to find that this collaborative research and development led to legitimate technological innovations. My lords, if I'm of no further indulgence to this honorable court, allow me make the prayers for the applicants. My lords, the applicants pray that this honorable court finds that Green Drive and Sky Connect had or enjoyed the dominant position, and as such, they violated that dominant position. And on issue 2, we pray that this honorable court finds that the joint venture between Ecomotors and Solar Wheels was independent of these two companies, and as such did not constitute to an anti-competitive cartel. On the third issue, and also our last issue, we pray that this honorable court is inclined to find that the collaborative partnership between Ecomotors and Solar Wheels also constituted to legitimate technological advancement or innovations, as looked at the aims of their objectives in the collaborative research. I rest the case of the applicants. Much obliged.
I just wanted to ask if, before the new respondents come in, if there are any other comments generally for the applicants.
Much obliged, my lords. My name is Edwin Nagenda, and I'm appearing on behalf of the respondent, on behalf of the respondent in this matter of locomotors and solar wheels against. In this matter of locomotors and solar wheels against. Much obliged, my lords. My name is Edwin Nagenda, and I'm appearing in this matter on behalf of the respondent, the matter of locomotors and solar wheels against Green Drive, the Attorney General, and Sky Connect. My lords, under the law of equity, he who seeks equity must come with clean hands. It is my humble submission, my lords, that by the time the respondent finishes submitting on this case, this court will be convinced that in fact the applicants have not come to this court with clean hands and therefore are not in line with the exact principles that they seek this court to submit on. My lords, I'll use 14 minutes of this court's time and I'll submit on issue 1. And my learned colleague, the Attorney General, will use 16 minutes of this court's time and will submit on issue 2, 3, and the prayer sought by the respondent. My lords, in regards to issue 1, I will have 2 main arguments. The first argument is that the exclusive agreement does not amount to an abuse of the dominant position, and the second argument is that Green Drive has a competitive edge over its competitors. However, my lords, before I delve into the submission of the respondent, I would like to answer a few questions that were raised to the applicant and a few of the things that the applicant said. My lords, as I respond to the applicant did not guide this court on what laws to follow. The applicant cited the Competition Bill 2022 of the State of Uganda and also cited the East African Community Competition Act. However, he did not convince this court on how these specific statutes or these specific laws, as he called them, can be applied to this honorable court.
I thought in his introductory keynote, he said there isn't much of jurisprudence and the bench should be guided by the persuasive nature of these laws and how they should be applied for particularly judging this matter. I thought that was the import. Is there anything in distinguishing that you want to say? Would you want to say that they needed to, with clarity, to say that this court should be guided by decisions of the EAC and exclude decisions of the United States? Is that your suggestion now in terms of distinguishing? But I felt in his introductory keynote he specifically said there isn't much of the jurisprudence and therefore he's seeking the bench's indulgence on that persuasive.
Much obliged, my lords. What I'm trying to clarify on before you, the honorable judges of this court, is that even when the respondent cites that these specific laws are persuasive, this court should note that the state of Wakanda is a dualist state. And in a dualist state, in order to apply an international treaty such as the East African Community Competition Act, that treaty has to be ratified. My lords, in the case of, in the recent case before the Court of Appeal, the judgment of Justice Christopher Gashiravake, the case of Stanbic Bank versus Nasanga Safina, Justice Christopher Gashiravake laid down that the Article 4 of the ILO Convention, which was in contention in that court and had been applied by the previous court in the High Court, was not actually law as it had not been domesticated.
But I'm not sure I follow, because the arguments were on municipal or laws that apply to the EU as a continental framework, not that they were international treaties that have been ratified by Wakanda. The arguments seem to be premised on borrowing from the practice in the EU, and those statutes, they are not treaties. Would you say they are treaties in as far as they apply to Wakanda?
Much obliged, my lords. The paragraph 2 of the facts before this honorable court hold that decisions and judgments from other common law jurisdictions, such as those in East Africa and the United Kingdom, India and Australia and United States hold persuasive value in this antitrust proceeding. Therefore, by the applicant using those decisions, he was simply stating that they are persuasive. However, the point I'm trying to drive before this honorable court is the application of the East African Community Competition Act. Yes, my lords. As I was submitting, this act, the state of Wakanda is a dualist state and hasn't ratified this act. However, as in that case of Stanbic versus Nasanga, Safina, where Justice Gachirabake refused to apply Article 4 of the ILO Convention because it hadn't been ratified, that was his decision, and this is a later decision. However, I would like this court to also refer to an earlier decision, the case of Katamba Hussein against Uganda National Rights Authority, civil suit number 18 of 2021, where the court in that specific case applied the different UNESCO conventions on cultural heritage, because even when those conventions had not been domesticated by the state of Uganda. My lords, I now, if it may please you, I will now submit on the first issue.
So if I get your stance of the argument, you seem to actually contend and then answer.
Yes, I contend, but I contend in order to guide this court that in following these rules, the court should know that there is a certain procedure that must be followed, and that procedure was not elaborated by the applicant.
It's very much appreciated.
Much obliged. I will now submit on the first argument under issue 1, which is that the exclusive agreement of Green Drive and Sky Connect does not amount to an abuse of a dominant position. My lords, the respondents cite clause 10, clause 3A of the competition bill in order to justify the aspect of that abuse of a dominant position because of this exclusive agreement. My lords, in their argument, they cite that Green Drive has a certain market share. If I'm not mistaken, the applicant said that it is 100% market share enjoyment. However, from the facts before us in this case, there is no explicit market share percentage provided for, and therefore it would be misguiding for this court to follow such an argument, because even from the facts, all they say under paragraph 3 is that Green Drive has a significant market share in the Wakanda electric vehicle sector. My lords, the applicant has also...
if I may, is it bad for there to be a participant in the market with a dominant share? Is that bad in and of itself as a matter of competition law?
Much obliged, my lords. If I am correct, your question requires me to determine what a dominant position is and also what amounts to abuse of that dominant position.
Should this court condemn dominant companies by virtue of their status?
No, my lords, because as the respondent before you also would like to bring to the notice of this court that in fact they concede that Green Drive is a dominant firm within the electric vehicle making industry in the state of Wakanda. So with competition law, it recognizes the fact that there can exist a dominant firm. It does not outplay the fact that there can be a dominant firm. If I'm guided, it's clause 8 of the competition bill. My lords, it's the one that my lords, the East African Competition Act, East African Community Competition Act, in this regard, recognizes a dominant position. Therefore, the dominant position exists. So, in the state of Wakanda, if the dominant position exists, what will amount to its abuse? This court should refer to the case of UCC Ubuntu versus American Towers Corporation and Airtel Uganda Limited. Much obliged, my lord.
What do you make of paragraph 5 of the fact? Because you've mentioned that applicants, rather the facts don't mention, there's no way the facts mention that will refer to the fact that Green Drive or Sky Connect don't have exclusive dominance in the, or they don't have 100%, you understand, dominance in the market. What do you make of paragraph 5?
Much obliged, my lords. Paragraph 5 highlights two main things, in my view. The first, that there exists Sky Telecoms, telecommunication network provider, and from these facts, it is also a dominant telecommunication network provider. The same paragraph, my lords, also establishes that Green Drive entered into an exclusive agreement with Sky Connect. However, my lords,
Before you go to that, the network Sky Connect exclusively offers 8G. When you say exclusive, it means there's no, it's the only service provider. So what would that mean? What percentage would you give an exclusive service provider?
much obliged, my lords. It would be, from the facts, one could suppose that this is 100%. This is 100% market share enjoyed by Sky Connect. However, that would be an assumption, and
Really? How can it be an assumption?
much obliged, my lords.
No, because I find it much very clear. I would understand if it read that Sky Connect is a major telecommunications network provider in Wakanda, which offers 8G frequency. But when you go ahead and use the word exclusive, that is, I find it's more like specific and certain that this is the dominant service provider. This is the one and only. That's how I would interpret it. You think it's still imposing? It's still 50%?
Much obliged, my lords. I do not contend that it's 50% because as Sky Connect offers that exclusive 8G frequency, it offers that exclusive frequency, the network license. It is the only player in the state of Wakanda that offers 8G frequency signals. So that puts it in this dominant position. But the dominant position it is in this aspect is that much as it enters that exclusive agreement with Green Drive, these two enterprises are in something that is a vertical distribution agreement, in that Green Drive will manufacture the smart charging chips, but for these smart charging chips to work, they must receive these signals from Sky Connect. So they feed on each other. They are not on the same level of production, but even as they are dominant, it is how they operate within the state of Wakanda. My lords, because arguing in regards to what you're guiding me to follow under paragraph 5 leads me to my second argument under issue 2, that Green Drive enjoys a competitive edge over its competitors in the state of Wakanda. In order to enjoy a competitive edge, you must have that advantage in competition, that advantage in the market, in that customers, consumers, and any other players, the competitors in the market, they acknowledge that you in fact have this competitive edge. when you have this competitive edge, it can result out of you being a fast mover. My lords, I submit that in fact, Green Drive, in this case, is a fast mover. Why? Green Drive was the first in the state of Wakanda to come up with this smart charging chip that can intercept 8G radio frequencies, specifically for remote charging of electric vehicles. So, by the time other prominent players such as Motors and Solar Wheels come into this aspect of coming up with smart charging chips that can access this 8G frequency, they are following the lead that had been laid down by Green Drive, which is a fast mover. In being, my lords, I request for 2 minutes to submit on this argument. My lords, so this court should also be guided by this scenario by the Amazon company. So Amazon was the first company to engage in online retail bookstores. So when it began engaging in that business, it was the only firm engaging in that business. However, when other enterprises saw that Amazon was making profits from this business, they followed suit. So they are just followers of this fast mover. So it is in this same case that this court should be persuaded to realize that Motors and Solar Wheels are followers of Green Drive, the fast mover. And because Green Drive is a fast mover, it has that brand name recognition. The brand name recognition is what gives it a competitive edge over its competitors. Because, my lords, competition law does not make it mandatory for dominant positions to enter into agreements with its competitors. However, competition law has to ensure that there is protection of consumers, because that is what it primarily has to address. Therefore, my lords, this competitive edge enjoyed by the respondent submits that this competitive edge enjoyed by Green Drive, this competitive edge that results as a result of Green Drive being a fast mover, is what attracts Sky Connect, who is also a dominant enterprise in the telecommunication industry, to enter into this exclusive agreement with Green Drive. Because any enterprise would want to enter into an agreement with another enterprise that has a brand name recognition, an enterprise that will make you profits, an enterprise that will not amount to abuse of competition laws.
Let me ask you, what issue are you trying to solve here? What issue are you trying to solve?
Much obliged, my lord. I'm trying to drive and to explain to this court my second argument, which is that Green Drive enjoys a competitive edge over its competitors in the state of Wakanda. And therefore, entering into this exclusive agreement does not necessarily amount into abusing its dominant position. Because since it is a fast mover and has a competitive edge, any other enterprise in a dominant position, such as Sky Connect, would like to associate with Green Drive because the quality Green Drive, because Green Drive is a fast mover.
Fast mover or not fast mover? The fact that you're dominating the market, whether you're a fast mover, whether you have a brand, a household name, you're affecting the market. Whether the fact that you're affecting the market and you've taken a dominant share. So whatever you're doing in your backyard, whatever I don't know, whether tricks or operations that are bringing you to the market, take the dominant share. That's not what the regulator is interested in. The regulator is interested to understand who is dominating the market. And these two, whatever techniques they're using, because to me, I'm looking at it like in paragraph 5, it's obvious because he owns the license, right? So there it becomes exclusive and he owns 100% of the market, right?
Yes, my lord.
That would also be the same as you mentioning that this is a fast mover. I mean, Green Drive being a fast mover, or even, I think, Sky Connect, whatever Sky Connect is providing, it could be that it could have been the first provider of 8G frequency. But what I'm trying to say is that can you please focus on proving that the market share, there's no, both Sky Connect green drive do not dominate the market?
Much obliged, my lord. So, when Green Drive and Sky Connect enter into this exclusive agreement, they do not, in fact, exclude the competitors such as Ecomotos and Solar Wheels, because as in the facts under paragraph 7, they form a joint venture, and we see later on in paragraph 10 that they introduce electric vehicles with smart charging enabled technology that could intermittently access 8G ultra-high frequencies. So, in this aspect,
What I'm trying to say is that I want us you to prove that they actually don't dominate they don't dominate, or they don't influence the market a certain percentage. That's what it should be, because I feel like your submissions are proving that actually they dominate the market. I would want you to show us that they actually don't dominate it, they only occupy maybe 10%. That should be your focus. What is coming out is that they're actually dominant. And you know why they're dominant? Because they have, this innovation which is so good, their brand name, and it's not their fault that it's their brand name or household name. I want you to prove that despite the fact that their household name or they have these exclusive rights, this is the market share they hold. Focus on the percentage. So, someone earlier, the applicant said that it should be 30% according to the competition bill. I want
Yes,
you
my
to
lord.
prove to us that the dominant position you're talking about does not exist. In fact, they only control less than 30%. That's where your focus is. Because right now, I feel like you're focusing more on proving the fact that they're actually dominant.
much obliged, my lords. First, I will guide this court to refer to the facts.
So give me an example to show that they actually control maybe 5% or 10, whatever, less than 30. Just give me an example.
Much obliged, my lords.
I know it's time is up, but I want to help you to have actually your issue to convince us more, because I just feel like you've spent most of your time showing us that actually those two companies are dominant for whatever factors you've mentioned. Your colleague, the applicant, mentioned as a percentage, and I want you to confirm this percentage is it from the competition bill, right? Just give us an example. If you don't have it, it's perfectly okay. So I'm also concerned about the time. If you don't have it, it's okay. But I just want you to understand where you are driving us and really, help you to focus more on showing us that the two companies do not have majority share.
Much obliged, my lord. The respondent submits that on the aspect of market share, the competition bill expressly provides that it can be 30% or any other percentage. So it is subjective depending on the jurisdiction. And according to the respondent, this dominant position enjoyed by Green Drive, really, from the facts again, the facts just show that Green Drive has a significant share in the market. Therefore, my lords,
I think you've lost your line of thought. Maybe your colleague will.
much obliged, my lords. I will use the floor to the Land Attorney General to submit on this issue.
Okay.
May it please this Honorable Court, my name is Felix Olindi, and on behalf of the respondent, I shall be addressing this court on issue 2 and issue 3, and as well present our prayers to this court. My lords, the crux of competition law is very simple. That firstly, we allow joint ventures or collaborations, but we do not allow them as long as they have an effect on competition. The case for the applicants is very simple, as I'm going to show you. The case for the respondent, my lord, is very simple, as I'm going to show you. Two companies, each with a prominent position in the market, identify a potential area of investment whereby everybody would like to enter. And instead of entering there as individual competitors to provide an opportunity for them to compete against each other, decide to form a collaboration, thereby foreclosing any possible competition between them, but also being on the road to creating a monopoly that is difficult to outcompete with other actors.
Does the creation of a JV necessarily forecloses, participation of the other entity? That's what you rightly said. So my question there is, does the formation of a JV necessarily forecloses on the participation of?
Your Lordship, my Lord, the respondent shall demonstrate that at a point in time where a company has the capability to independently and to enter a market independently and efficiently act, then it is not justified to enter into a collaboration with another company so that they foreclose any competition with them.
So your argument is that these people are already good, they needed not to have a JV. And where they entered the JV, they closed out.
Yes, my lord. Okay. My lords. But secondly, under competition law, competition law is meant to protect innovation and promote research and development, meaning that people that come up with novel ideas must be given the opportunity to benefit from them. Your Lordships, for that reason, I shall be demonstrating to you firstly that the collaboration between the joint venture transformed into an anti-competitive cartel, because firstly, we shall submit that they had an adverse or appreciable effect on competition by foreclosing any possible competition between themselves, even when they were possible competitors. But also secondly, they had the effect of creating a monopoly in the state or Republic of Uganda. But secondly, under that, we shall submit that the sharing of sensitive business details amounted to anti-competitive behavior, which therefore transformed them into an anti-competitive cartel. Under the third issue, Your Lordships, the applicant, the respondent shall submit that firstly, the innovation by the applicant does not meet the test under the Industrial Property Act of novelty, having an inventive step, and then thirdly, being industrially applicable. May it please this court, I shall address you on the first issue. My lords, competition law says joint ventures are fine, all collaborations are fine, but as long as it's possible to establish that they have an appreciable effect on competition, then they are not sustainable and they become anti-competitive. Your Lordships, the first test, as laid out in the case of Matheson Olin versus the Penal Salt Company in 1960, the case that laid down this principle. It said, firstly, in ascertaining the capability of a joint venture to close out future competition, you question whether they had the ability to act independently. But secondly, whether this acting in collaboration had the effect of foreclosing any competition between them. My lords, this respondent submit that by mere fact that these are two prominent companies, and from the facts it is not actually clear or mentioned anywhere that they cannot independently create this particular SCC-enabled charging chip, then it is not justified for them to form this particular venture. But as per paragraph 7, moving to my second subhead of argument, my lord, the intention of this joint venture is to create a cost-effective ride-hailing service. My lord, in the market, this is how a ride-hailing service works. That if I'm a manufacturer of a car and I'm running a ride-hailing service, I am going to require you, before you become a rider with my company, to buy a car from me. My lord, such conduct has amounts to what we can call a tying agreement. To that extent, you're forcing people to buy your product. What is the effect of this on competition? Your Lordship, we submit that firstly it creates a monopoly. At a point in time where the joint venture becomes strong enough to be able to entice or to provide better incentives to people to come and ride for it, companies like Green Drive that may not necessarily provide a cheaper cost or a cheaper method do not necessarily benefit. Your Lords, my Lords, competition law is not necessarily about keeping the price very low. It's about keeping the price fair for all actors to remain relevant in the industry. The actions of the applicant, as we submit, have the effect of foreclosing other efficient actors from other efficient competitors from the market, firstly, by creating a situation where they are forced to reduce the prices of their products so that they can meet this competition. My Lords, in the European Union case, in the European Commission case,
and rightly so, like you said in your introductory note, you said that competition law really fosters consumer-centric.
yes.
So if in paragraph 7 these people are entering into a JV to have a cost-effective mechanism, don't you think they are easing the problem?
My Lords, the effect of such a collaboration is even beyond, it's against the consumer-centric values that we seek to. At a point in time where a company is forced to reduce the prices for its products, one, it means that it's going to look for alternative ways of cheaply producing that product, my Lords, so that they still have a particular profit margin that they can maintain and remain relevant in that particular market. My Lords, the case of the applicant.
Something interesting the applicants also said. Had you say, the consumer-centric approach as you're talking about, they also did mention the effect balancing test. And they said, that was clearly in their favor. So maybe you would show us what the effect was really.
My Lord, from the applicant, the effect balancing test basically cares about the effect of a particular collaboration on the market. From my understanding of this test by them, this test only cares about the effect of this collaboration on the competitor and not necessarily on the consumer, my Lord. Your Lord, I shall proceed to address you on the...
So what's your submission? What's the effect of this JV? What's your submission?
My Lord, this JV has the effect of becoming a monopoly, strengthening its position in the Wakanda market and foreclosing other parties.
Again, is it wrong for a monopoly to exist?
Much obliged, my Lord.
Or are we concerned with the anti-competitive effects that arise from the monopoly? So is this a crime by status? Is it wrong by status or by the effects that follow?
My Lord, from the start of the respondent submission, it was clear that having that dominant position is not bad, but how you use that dominant position to influence the market is bad. My Lords, we submit that the joint venture has the effect of affecting competition in the ride-hailing business, firstly, by offering time agreements, but secondly, by offering low prices for their services, which would force other consumers, even after so much investment in their technologies or producers, to reduce their particular prices. My Lords, I shall proceed to address you on the second sub-issue. My Lords, sharing of sensitive business details amounts to anti-competitive behavior. And for this reason, we submit that because they shared information beyond the scope of their collaboration. Key to note, my Lord, is that joint ventures act independently. This means that for a collaboration, for information sharing to remain within the scope of a joint venture, that information must only be about the object of the joint venture. When the facts tell us that they go beyond the scope of the joint venture, it means that they go and talk, for example, about how to maybe allocate prices in other places of businesses, but also the effect here.
You look together. the introductory note said that we need to take note of equity. Who carried out this investigation as you're qualifying it under paragraph 13?
My lords, carried out a private investigation.
So how certain are we that the investigation you carried out is not what you're pointing to them? You're the judge, you're the jury.
My lord.
And now you're saying, we've already decided that, and you're presenting it as basis before court.
My lord, the private investigation we carried out was used to help the decision of the Wakanda Antitrust Regulatory Committee. We do not have the power to decide that they constituted anti-competitive behavior, so we cannot say that it's on the authority of this particular investigation that we judged them, your lords. My lords, I shall continue addressing you on the sharing of information.
Can you address us on some of the decisions where some courts have said that sharing information at a horizontal level is anti-competitive?
My lords, the United States, in the case of the Verizon case, my lords, laying down the principle that most notably quoted, saying that cartels are like the most evil thing in competition law. And the basis for that was that Verizon Inc., a mobile telephone operator, had connived with another mobile telephone operator in the United States, and they were sharing information, market information, to the detriment of the users, my lords. And the court therefore held that such an act was anti-competitive, your lordship. My lord, may it please this court, I shall proceed to address you on the third issue. Your lordship, the Industrial Property Act lays down a tripartite test for determining the legitimacy of a particular innovation. Firstly, that innovation must be novel. Your lordship, it's the applicant, it's the respondent's averment that the SCC-enabled chip that is developed by Solar Connect and Ecomotors is not as novel as envisaged under the Industrial Property Act. What does novelty mean in the context of this particular act? Firstly, it must not be anticipated by prior art, to that extent that there must not be something existing that is similar to what you actually created. My lords, from the facts, you can identify that the SCC-enabled chip that is developed by the applicant has similarities with that chip that is actually created by the Green Drive. But your lordship, that defense could be that they were denied access to this particular technology. My lords, the only time when companies have mandatory access to particular innovations or technology is when they have been declared standard essential patents. What amounts to a standard essential patent? The courts have laid down a particular principle, for example, in Huawei versus Digital, that firstly, that by virtue of refusal to give you access to that particular technology, you could not find a way to go around it, meaning you could not create a similar product like that. But secondly, you're completely foreclosed from the market and you cannot act. Your lords, my lords, such a defense does not work because even after the denial of that particular access, they still created a similar product, meaning that this product did not fit the test of an SCC or of a standard essential patent. But secondly, they still remain competitive in the market, your lords. My lords, the second test is that of the inventive step. The inventive step simply means that there must be something distinguishable, my lords, about this particular innovation. That means that there is prior technology, my lords, but there must be a special element that distinguishes this particular new innovation from that. My lords, it is actually our submission that from the description of the SCC-enabled charging chip created here, there is no particular distinguishment between what is created by Green Drive and that is created by Sky Connect. They may argue, my lords, that their chip had the ability to access 6G, 7G, and 8G frequencies. My lords, it's our contention that the 6G, 7G frequencies were already accessible in the Republic of Wakanda. Meaning that if they wanted to create something with an inventive step, they had to go beyond what was created by Green Drive. An inventive step is something that revolutionizes the world market and industry. By virtue of the creation of the Green Drive, the industry will revolutionize. So we expected the joint venture improving the legitimacy of their innovation to show us that they surpassed the revolutionization that was brought about by the 8G technology developed by Green Drive. Your Lordships, the last aspect is industrial applicability. The applicant would like this court to believe that the fact that this particular chip accesses frequencies intermittently is actually a good thing. But this is not actually how the market works, my lords. Firstly, that as long as a car, for example, will require an 8G charging chip to charge, it will not allow 6G, 7G. It was incumbent upon my brothers, my colleagues from the applicants to show us that these particular elements or aspects promote like the interoperability of this particular innovation. But my lords, they actually do not, and it's our submission that because of this glaring flaw, this particular innovation cannot be relied upon in an industry that is struggling to run away from pollution and also to be as clean as it can be, your lordship.
You make your prayers.
Much obliged, my lords. My lords, the applicants, the respondents, pray that this court finds that the exclusive agreement between Green Drive and Sky Connect for access to the 8G ultra-high frequencies does not constitute an abuse of a dominant position. But secondly, that this court finds that the collaborative partnership between the joint venture has transformed into an anti-competitive cartel. And lastly, like I've showed you, that their innovations and collaboration in research and development do not satisfy the test and so are illegitimate. My lords, the applicants pray that the decision you make today has an effect on how industry actors will approach research and development and innovation in the state of Wakanda. You either encourage them to innovate for the growth of the industry or break the industry with no innovation. I beg to submit, my lords.
Thank you very much. Judges, do you have any comments?
Thank you, my lords. First of all, I would like to note that it is always an honor to stand before you and tap from your cup of wisdom. My lords, I will respond to the affirmations made by the respondents. My lords, it's a surprise that the Attorney General is not convinced that desperate situations require desperate solutions. We are surprised that he is in fact discouraging innovations. Now, my lords, the Attorney General has opened a wide door to patent law. He took us back to the basics of patentability, of which I know this court has taken judicial notice of. My lords, we are aware of the Industrial Property Act, 2014, laws of Uganda, specifically sections 9, 10, and 11 that provides for novelty, taking an industrial step, and if the innovation is industrially applicable. We are not before this honorable court seeking for patentability. No, we are not. My lords, we are simply saying that there is an innovation, and as such, that innovation has come from a joint venture, and that joint venture carried out what we call collaborative research and development, and they came up with this innovation. What we want this honorable court to determine today is that that joint venture did not constitute into an anti-competitive cartel, and that joint venture did not lead into illegitimate technological innovations. My lords, I will also address this honorable court to the affirmations made by the respondents, specifically on the objective of the joint venture. My lords, the objective of the joint venture are clear under paragraph 7 of our facts. They wanted to come up with an innovation of new remote charging systems and also to come up with a cost-effective ride-hailing service. My lord, a cost-effective ride-hailing service does not in per se mean that we are looking at low prices or fixing prices. No, we are looking at affordable prices by our citizens in Wakanda, and that is what we call problem solving. My lords, with that, we submit persuading this honorable court with the decision of the Supreme Court of the United States in the United States versus National Lead Corporation, which looked at a joint venture and agreements thereof as being agreements of minor importance. My lords, the Supreme Court of the United States applied the maximum of law of the de minimis rule, which says that de minimis non curat lex. All small things the law knows no cure. With that, we submit that the averments of the respondents do not hold water in this argument. My lords, we also submit that on the position of a dominant, on the arguments of a dominant position, my lords, as earlier on guided by his lordship, he clearly guided that having a dominant position is not the problem, but agreements, decisions, and concerted practices that come from a dominant position constitute to an abuse, and that is where the position is. My lords, we agree that Coca-Cola could coexist with other companies like Reham and Pepsi, but that in itself does not mean that it has violated any antitrust laws. So we pray that this honorable court finds that since they considered that Green Drive holds a dominant position, that this honorable court finds that it violated that dominant position by foreclosing other competitors in the market by entering into a non-exclusive agreement with Sky Connect, and also leverage its powers to dominate the market of the smart charging technologies, and also, your lordships, to find that indeed the collaboration between Eco-Motors and Solar Wheels did not constitute to an anti-competitive cartel, since we have established that a cartel in itself is not the problem, but decisions, agreements, and concerted acts that come from a cartel are what are the problem. And since there is no evidence in the facts that the joint venture violated any anti-competitive laws, we submit that this honorable court finds that there was no anti-competitive cartel. On the third issue, which is also the last issue of the applicants, we pray that this honorable court finds that the collaborative research and development between Eco-Motors and Solar Wheels was intended for legitimate technological innovations as established under paragraph 7 of innovating new technologies of remote charging and charging chips, and the technology of cost-effective ride-hailing services. With that, my lords, the applicants rest their case. When you sit to deliberate on this matter, my lords, it is imperative for you to note that the decision that you're going to come up with is going to be the genesis of competition law in the Republic of Uganda, and as such, it is important for us, you, and the whole Republic of Wakanda at large. Much obliged, my lords.
Much obliged, my lords. The principles of competition law, as established in all the jurisdictions that the applicants give you, acknowledge that commercial agreements are not necessarily bad. 2, dominant positions are not bad, but how you use those dominant positions, how you use those agreements to affect the market competition is what is bad. Your lordships, firstly, the applicant submits that that they did not. The applicants firstly submit on the issue of patentability. My lords, they aver that the case before this court is not for patents, but this court is required to just consider the legitimacy of this particular innovation. My lords, it's our submission that such a test or a basis is rather misleading to this court. In the case of Google versus Oracle,
my lord. In justifying or in determining the legitimacy of Google's Android system that was on Google's Android system, my lord, the court used these particular steps that have been outlined in the Industrial Property Act, whether Google's Android system was novel, whether it had an inventive step, and whether it was industrially applicable. In this case, my lord, Google was not seeking to patent the Android system, my lord. Or Oracle was not seeking to patent Java. What it wanted was this court to determine whether Google's actions were legitimate or were not legitimate. My lords, the Organization on Economic Cooperation and Development in 1998 issued recommendations for combatant action against cartels. My lords, throughout the submissions of the applicants submit that cartels are per se or are principally not wrong. My lords, it's our submission that this court takes attention and the kind of language that is used to define. The East African Competition Act and East African Community Competition Act under Section 8 clearly says that anti-competitive cartels are prohibited. But it also says that horizontal agreements or agreements that have an effect on competition are bad. My lords, the question before this court are not cartels, because this court already agrees that cartels are bad. But this court is questioning to what extent do agreements between organizations or joint ventures between organizations become anti-competitive cartels, a test that the applicant actually fails to show. My lords, as I conclude, the decision you're going to make today is supposed to base on the principles of international law, of competition law, intellectual property law, as has been elaborated by both sides in this debate. And clearly, you'd like to show that having a dominant position is not bad, but how you utilize it to affect competition is bad. An agreement is not bad, but how you use it to affect competition in the market is bad. Coming up with something is not bad, but how legitimate is it? That is the question, my lord. I yield the floor.
All right. Congratulations. Well done. Well done. I think from 8 a.m. It's now, I don't know. Yeah. Very dark, but well done. And I would like to say you've from the very first preliminary round out to the final, there's tremendous change, both to the inference of authority, how you apply, and generally your appreciation of even the principles therein. So my very general comment and observation is that it gets better as you read the more. So my very last comment will be, when you signpost, please take us there, right? So don't say, I'm going to take you to Cavendish and you take us to Makere, or you take us to Chambogo. But even when we take you to Chambogo, be able to get back to where we would like you to be. If it's Cavendish, please be back at Cavendish. The essence of that is that a moot is not that you're able to answer everything you've written in that notebook of yours. It's just the ability for a judge to say, is it bad for somebody to have a monopoly? And you say, rightly, it's not. MTN is the largest consumer of what? Maybe users, right, in the country. It's not bad. Maybe it's bad maybe because of this and all these things, right? So for me, I'm just saying, don't stick to that written out speech. Just prepare the ability to know that once I'm picked up on a question, it's either pointing me to a direction where I respond quickly and I get back to what I'm saying, but also the ability to think off my feet. I think that's what I'll leave to you. It's when you become a very outstanding oralist, sticking to, everybody has read the, the competition bill and all these things, but your ability to get off that and then apply the principles is what makes you outstanding. But well done, and all the best to the winning team.
Thank you very much. I thought this was a very good presentation overall. I think this is a fairly novel area, especially for our jurisdiction. So making these arguments is not entirely easy. So you have to give credit to yourself for doing that. Perhaps you should clap for them. Having said that, I feel there could be a deeper appreciation of the comparative elements of competition law. Some submissions suggested that the approaches are the same in EU and the US, and I don't think that's entirely true, because one jurisdiction is more protective of innovation and another seeks to share more knowledge and focuses more on consumer protection. So it may be a little bit misleading to cite all of these jurisdictions as if they say the same thing, when the US Supreme Court is very, very reluctant to touch and to restrict private players, because that's the hotbed of their economy. So I just feel like it could be very, very good if we appreciate the divergences in approaches and what that means for the cases you argue, as opposed to putting it under one blanket. But otherwise, I think the submissions were good, certainly above average, and thank you.
Yeah, maybe just briefly, and to say that indeed at this level of the competition, much more is expected, and I would like to say that, in comparison to definitely the other round that we had earlier on in the day, there's been an improvement generally at this level. I wouldn't be surprised. Maybe just a few things to say, and I will try to spring off what my colleague Gerald here said, especially in regards to the fact that this is a novel area, and it being a fairly new area. One of the important things at this stage of the competition is to ensure that you're communicating. Going around with technical words and whatnot sometimes can easily lose the judges. So you want to ensure that you are communicating at the end of the day. And then the other thing that I wanted to say is also try to focus on what is most relevant. I do not think, in the experience of scoring, such sessions that, there is regard that is had to who has cited the most authorities that, on the other hand, however, do not introduce anything new or fundamental to his argument. So make sure that you're trying to be selective in what you want to present first, and just be precise to it. If it doesn't introduce anything new to your case, then leave it out. That way you're saving a lot of time to be able to answer more comprehensively and meaningfully any other questions that might come along the way. Otherwise, for me, this was impressive, and I commend all the participants that took it out.
Yeah, thank you very much. I think all the judges, I would want to agree rather with them, but I think for me most importantly what I want to point out is the fact that the area you are handling is a very young industry, especially in our country. So, I think you did well. You did very good research. It's just a few, maybe these are just techniques of court. What I just wanted to point out is that sometimes when you look at, and when you read an issue, it's always important to focus more on what, how you'd want to prove, how you'd want court to understand your case, than to, how can I say, malign your opponent. I find that the best technique is that make your case very understandable instead of actually focusing more on bringing down, I guess, the opponent, right? I like the fact that all the you call them oralists? Yeah, they were very confident, and you knew what you wanted to submit, and you were very, I guess, sure of the sources you had got, and the cases you are citing. Maybe another thing I wanted to share is that I noticed most of you were going abroad, like, okay, referring to, I think, the US. Next time, please look more into, I know the UK has very good competition laws that we have actually used in the past, because of our relationship with the UK, this is something usually is the first point of reference. And then, I don't know if you've heard of the Commercial Competition Act. It's also something in practice we use a lot, because we don't have any specific law. And actually, we have laws in what they call competition regulations or laws or provisions under specific acts. I noticed that you guys didn't even mention that. We have under the Communications Act. I don't know if you did look it up, because this involved which communication company was that? Sky Connect, right? Yeah. So I didn't hear anyone mention or referring to our competition laws under that specific industry. So we don't have a specific act, but we have competition law, provisions, regulations under other acts. So this is something you should, I guess, expand your research, especially in that communication sector. I feel like you missed that out completely, and you are all into US laws and all that. But anyway, I generally think that you did a great job. The only thing you didn't do well is time. Have you seen the time? Look at the time you're here, guys. That's the only, we are giving you very, very low scores on time. So, next time you do better. It's 8 o'clock, guys. Right? Yeah. Yes, what are you going to do next time? Just make sure next time you get is it the timekeeper? Who should we blame, by the way? Judges, who should we blame?
It's hard to tell.
It's hard to tell. Someone has to take responsibility. We want to sort this thing out so that next time it doesn't happen. It's 8 o'clock, guys. Some of us have to cross valleys, mountains, and first fight some lions to get to our homes. Now, guys, judges, please tell me, what score should we give them? We need to give them a very, very low score on time. But anyway, thank you very much, guys. So you give us some time, because we need to get actually the overall score. So give us like maybe 4 hours, then we'll get back to you. Yes, you made us wait, so it's your turn now. Anyway, how many minutes? Like 10 minutes. Okay, maximum 10 minutes.
All right, so we're over to Ivy.
So we need to come up with an overall review, and also the best speaker.
Good evening, everyone. My name is Ivy. I am newly married. So my name is Mrs. Turia Sungira.
I'm responsible for 10
Truly, we take all the responsibility and we really apologize. I would like, first of all, to thank all our judges. They have really been patient. The participants and everyone that came to watch, you have really been patient. We really appreciate. For now, as we wait for the judges, it will just be a 5-minute break, and we announce the winners, we give the prizes, and we all go home. Thank you.
As we wait for the judges' outcomes, let me read the certificates. Chimono Stella. Orishaba. Oh, these are participation certificates. Orishaba. Amumpiri Nixon. Ngabirano Mark. Katwondwa Chipal. Mirembe Leader. Birungi John. Birungi John. Felix Olindi. Edwin Calvin. Sereko Marvin. Areva Jonathan. Are there any mooters without certificate? Anyone else without a certificate?
Okay, let's start.
As we come to time for the awarding ceremony, let me ask all of us to fill up these empty seats at the front. Thank you.
So for you, team what? That's what? Team G. Best, then you. Team 2. This is 70. This is 73. This is 76.
I've reduced team H and
5. I like the point 5.
Yeah, in terms of they had 141 in total, this was 140.
Sorry to interrupt. We also need the best speaker.
Yeah.
So maybe we can.
Best female oralist is Mirembe Linda. Congratulations. The best male oralist from the preliminary rounds is Mr. Jonathan Areva. We're also going to award the best overall written submission, and this goes to Team G, Makerere University. Thank you, Mr. Okema. A quick word, Mr. Okema is the MSME expert at the Ministry of Trade, and when the competition bill is finally passed, they will play a very big role in competition law in the country. So, it's now time for the big moment. We have tallied the average from the judges' tallies, and with 77%, Team G are the winners of the 2023 State. Congratulations, Team G. Team H came in second place with 75.7%. So it was a difference of 1.3, if I'm not mistaken. Yeah. So I will ask Team H, that is KIU, to come for your award. I'll ask the lead judge to give you the award. So that's Team H. Congratulations. And the plaque. Thank you. The best overall, congratulations, Team H. The best overall oralist is Mr. Felix Olindi. Congratulations, Felix. And the winners of the Technology Law Moot Court Competition 2023 are Team G, Makerere University. All right, thank you so much. Thank you all for coming, and thank you to the judges. Thank you for your time. We've had a good day, and I wish you all the very best. I would like to thank our partner, Nalo. A hand clap for Nalo. Do check out their socials. They have been posting the whole day, and give them a follow. Thank you.